Now, speaking of indisputable existential threats, our next case we will be covering is U.S. v. Cruikshank. All right, up next we have United States v. Cruikshank. Now, the facts of Cruikshank are pretty gruesome. In 1872, competing factions of the Democratic and Republican parties had both claimed to have won the office of judge and sheriff in Grand Parish, Louisiana. In March 1873, a Republican faction of African American soldiers seized the courthouse in Colfax, Louisiana. They were armed with the rifles that they had carried as Union soldiers. 150 white militiamen attacked the courthouse. The armed militiamen were unable to overcome the armed resistance of the freedmen inside and to breach the courthouse. So they instead decided to set fire to it and essentially smoke the freedmen out. Now, more than 100 freedmen were shot and killed as they fled the inferno, even after they had surrendered to the militia. This slaughter became known as the Colfax Massacre. Now, William Cruikshank was one of the lynchers. He was prosecuted in federal court. The indictment alleged that he had violated the victim's constitutional rights, namely the First Amendment right to peaceably assemble and the Second Amendment right to keep and bear arms, but this was under the Privileges and Immunities Clause of the 14th Amendment, which is why they could hold him accountable for a state crime in a federal court. Now, 4 decades earlier, Chief Justice John Marshall had declared in the 1833 case, Barron v. Baltimore, that the Federal Bill of Rights only limited Congress's power. So, under this case, the First and Second Amendment would not have affected a state's police power. But was Barron still good law following the ratification of the 14th Amendment? Well, Representative John Bingham very clearly during the congressional debates suggested that it would not be. However, the Supreme Court disagreed. Chief Justice Waite wrote the majority opinion in Cruikshank. He found that the states were still not bound to protect the individual rights found in the first 8 amendments, even after the 14th Amendment's ratification, despite the Privileges and Immunities Clause, as described by John Bingham, as protecting these enumerated rights in the Constitution. Now, next here, I want to play a clip from a constitutional law scholar, Randy Barnett, where he is talking about the implications of Cruikshank on the 14th Amendment, because he will be alluding to a point that we will be discussing a little bit later on in relation to the 2010 case of McDonald v. Chicago.
The clause would only protect an insignificant set of federal rights. To compensate for the deleted Privileges or Immunities Clause, the Supreme Court would gradually expand the scopes of the Due Process and Equal Protection Clauses far beyond their original meaning. Slaughterhouse remains good law today. Over a century later, in 2010, Chicago residents invoked the Privileges or Immunities Clause in an appeal to the Supreme Court. They claimed that Chicago's ban on firearms abridged their right to keep and bear arms. And to reach that result, they urged the Supreme Court to reverse both Slaughterhouse and Cruikshank. However, in McDonald v. Chicago in 2010, Chief Justice Roberts and Justices Kennedy, Scalia, and Alito declined that invitation. Instead, they relied on the court's expanded reading of the Due Process Clause. Only Justice Clarence Thomas cast his 5th and decisive vote based on the original meaning of the Privileges or Immunities Clause. So in this case, at least, the Privileges or Immunities Clause had a big impact.